happen. Now, back to Geoffrey Nathan in Boston and the Aaron Hernandez case. I want to bring in Mr. Nathan to talk a little bit about Massachusetts law and this double homicide that Aaron Hernandez is facing. As you know, Aaron Hernandez is already in prison for another murder committed the year after the double murder he's currently on trial for, and he is serving life in prison, but jurors don't know about that. So, welcome, Geoffrey Nathan.
Pleasure. Thank you, Beth.
I want to talk to you first about the star witness for the prosecution, Alexander Bradley, who says he was driving the car that pulled up alongside the BMW that had 5 occupants in it on July 16th, 2012, in the wee morning hours. And he says the passenger in his car was Aaron Hernandez, and Hernandez leaned over him and fired into the BMW, killing 2 men and wounding another. So there's 3 attempted murders and 2 murder charges, as well as other charges, for a total of 8 counts. This case could not have been made without Alexander Bradley. And the prosecution gave him complete immunity. There are issues when the prosecution does that, right? I mean, really, this whole case boils down to who the shooter was. The defense says it was Bradley, and the state says it was Hernandez, and Bradley told us that, and we believe him, and we gave him immunity. What do you do with that when you're a defense attorney?
Muddy the waters as best you can, and then try to bring up to the jury the fact that the witness is testifying pursuant to a deal, the deal that undermines the credibility of his testimony. And then you try and put before the court a motion that says, look, this witness is testifying pursuant to a deal, and the deal is that he is providing slanted testimony to protect himself from prison time. The job of the defense is to elicit that fact, plus to then question the witness as to whether or not he's lying and whether the government induced him to slant his testimony to favor their theory of the case, Beth.
But there was a point where Judge Geoffrey Locke cautioned Jose Baez, as he was cross-examining Bradley, about bringing out the details of the immunity agreement. And he said, you know, I caution you, be familiar with what the Massachusetts Supreme Judicial Court, that's your highest court, says about it. I did a little research. I'm not sure that I, was reading all the right cases, but they were in the last, 4 to 7 years or so. And they do say that, the immunity agreements can seem to be vouching for the credibility of a witness, and of course prosecutors can't do that. But why was the judge, do you think, cautioning Mr. Baez to be familiar with the Massachusetts case law?
Well, for several reasons, Beth. First and foremost, Baez, we know, is licensed in another state, but has been admitted what is called pro hoc vice for the limited purpose of appearing in this particular case. And he's sponsored by a lawyer from Massachusetts, but who is actually from another county. And then that lawyer's background is not in criminal defense work. It is in corporate and municipal law, so that the judges will look at the background of the attorney, and if it's not an attorney who's familiar to the court, the judge has the right, and the duty, and the obligation to question the attorney. It's without the jury being present, to ascertain whether the lawyer has had sufficient time to prepare, or whether he's being rushed or needs more time. It's not the judge's job to educate the lawyer on the law, but it is the judge's job to make sure that the defendant has an effective attorney. And you're not effective if you don't know the cutting-edge case law, and that's what the judge is doing in this instance, Beth.
So the jury does know that Bradley has cut this deal, and they should know that, right?
Oh yeah, I mean, the jurors have to know whether there's bias or a reward, like I said, or some sort of reason as to whether or not the witness's testimony is being proffered to the jury under, a deal. And this happens all the time in difficult to prove cases, say where there's no weapon or no body, as we'll see later. But in this instance, it's very, very common in murder cases for witnesses to testify pursuant to a deal. Now, in this instance, it's an unbelievable deal. I mean, the witness is getting off scot-free. I mean, wow, that really means something. That means that the prosecution felt that they had a very difficult case in chief against Hernandez, and that there was a substantial chance that Hernandez could be unanimously found not guilty, and as a consequence, they had to give the witness the absolute and total best deal that can be cut in criminal defense. Kudos to his lawyers.
You know, you can't be charged. I mean, you can't be tried twice for the same crime, but he's charged with witness intimidation for a shooting in February 2013 of Bradley, right? That he tried to silence Bradley and shot him in the head and left him for dead in Florida. So I haven't looked, but I assume he's facing attempted murder charges in Florida. Let's just say he is. Okay, so he's facing, let's just hypothetically, because I don't know for sure, they say that he's facing attempted murder in Florida and witness intimidation now in Massachusetts for the same shooting. Say he gets convicted, or it doesn't matter, whatever the result is. He's tried to a verdict. Conviction or acquittal of witness intimidation. Does it have any effect on an attempted murder in another state? Same shooting.
I don't think so. I mean, I don't think if he's brought to trial in Florida, I'm not so certain that Florida would want to dabble in those waters to bring out a Massachusetts conviction. I mean, it's just a straight shooting case. So I don't think that Florida prosecutors, if they do go there, would necessarily want to bring out a Massachusetts conviction. And I'll say this much. Even if he is convicted, it's terribly difficult to introduce records of prior convictions. State laws vary from state to state on this, but it's difficult to do, and they may not need it. So I think.
But can he be even prosecuted? What I'm saying, there's no jeopardy, right? Because they're different crimes. Same incident, though.
Same incident, different crimes, different jurisdictions. So, in my opinion, prosecution is viable.
Now, the defense had made a big deal with Bradley on cross-examination. Jose Baez spent quite a bit of time questioning Bradley about the number of shots fired, because Bradley originally said, it was a 6-shot Smith & Wesson revolver. Actually, Bradley thought it was a .357 gun he had supplied to Hernandez, but the state says the murder weapon was a .38 Smith & Wesson. It was a 100-year-old gun at the time. Now it's 104 years old, 1913. He says, he must have fired all the shots because there were several shots fired. There were 5 out of 6 that were fired. So he makes a big deal out of it. And I just wanted to listen to a little bit of the cross and then redirect of this and ask you afterwards about, just to react to it. So let's go, Anthony, to the cross-examination by Baez regarding the number of shots fired from March 22nd. It's number 2.
The day before yesterday, you said that Aaron Hernandez had shot the gun 5 times, right?
Correct.
The day before yesterday, you said that Aaron Hernandez had shot the gun 5 times, right?
Correct.
And when you were quite clear about that, right?
Correct.
Okay. And this is something that you just have in your memory, hearing 5 shots, right?
Correct.
And in fact, you were able to distinguish the difference between 5 shots and 6 shots, right?
Correct.
Okay, because you said 5 shots, right?
I believe at one point I said 5 or 6 and 5 as well.
I know you know where I'm going, but my question to you, sir, is at some point...
Put a question to the witness without commentary,
when you
please.
testified to the jury, you told them 5 shots, right?
Yes, I recall saying 5 or 6 shots as in a testimony as well. So
I'll repeat the question because I don't think you're understanding. When you testified to the jury, you said 5 shots.
to the jury, I believe so.
You believe so?
Yes, I believe so.
Okay. You were unequivocal. You said absolutely. You said 5. You didn't say 5 or 6, right?
I said 5, correct.
All right. Now, The first day that you spoke with law enforcement and you gave your proffer under that letter, do you recall being asked, how many shots do you think were fired? And you answered, oh, that gun has 6 bullets. So he had to fire every bullet in there. Did you hear? The next question. How many did you hear? Answer, 6, probably 6, about 6. Question, okay. Do you remember that?
I believe I said that gun holds 6 shots.
No, your exact words was, oh, that gun has 6 bullets, right?
If those are my exact words, then yes.
Okay, let me show you them so we don't get...
That'd be better. Thank you.
May I push witness?
You may.
I'm showing you your statement of October 8th proffer that was based on the proffer letter for which you were ultimately granted immunity. There's your answer highlighted in line 20 and 21.
Yes. Those are my words. Accurate.
Okay. And accurate means, oh, that gun has 6 bullets, right?
Correct.
So we had to fire every bullet in there, right? You said that?
Correct. Those are my words.
Now, you also said that after the gun was fired, you heard the clicking sound, meaning...
So that was Jose Baez on cross-examination asking Alexander Bradley about the number of shots that were fired, because he told the police that it was a 6-shot revolver, that probably he thought he heard 6 shots, that the gun must have basically been emptied, when in fact only 5 shots were fired. This was a point that Baez was hammering constantly on cross-examination. He came back to it a few times over the course of the 2-3 day cross-examination. So let's just listen to this next clip from the same day, 2 days ago, March 22nd. It's number 6, Anthony, and it's the redirect where the prosecutor is saying, like, what's the big deal about 5 or 6 shots? And then I'm going to ask you, Geoffrey Nathan, to react.
On cross-examination by Mr. Baez regarding whether you heard 6 shots or 5 shots. Do you recall those series of questions?
Yes, I do.
And I believe you indicated on cross-examination that when you testified before the grand jury, you said how many shots in the grand jury?
I recall saying 5 shots.
And I believe Mr. Baez called your attention to your initial statement on October 8th, 2013, where he read a portion to you that said about 6 shots or something to that effect. Do you recall that line?
Objection, Judge. That's not what the transcript reads.
Put the question.
What is your recollection as to what you said on October 8th?
Objection, Judge. I would ask that you use the actual transcript instead of trying to minimize it.
The witness may answer that question.
I don't know if it's exactly on the 8th, but I know at one point I said 5 or 6 shots.
And what, if any, confusion was there for you as to 5 or 6 shots?
Objection, Judge. If he answers a question about the statement, I would ask that he use the actual transcript instead of
Repeat the question, please, Mr. Hagan.
repeating the false testimony before the jury.
Overruled.
What, if any, confusion was there between 5 or 6 shots initially for you, sir?
Well, I would guess that I just know that type of gun holds 6 shots. So,
Did you hear any noises after the shots were fired?
yes, I heard clicking noises.
And just based upon if you know, what noise does a gun make when it's empty, a revolver, and you continue to pull the trigger?
It makes a clicking noise when the gun's empty, when the chamber's empty.
But ultimately, Mr. Bradley, you've already testified to this. You testified in the grand jury to hearing 5 shots, correct?
Correct.
Did anybody prior to you testifying in the grand jury, whether it be police or prosecutors or anybody, suggest any significance whatsoever to 5 shots versus 6 shots?
No, sir.
Was there any conversation at all regarding 5 shots versus 6 shots from prosecutors or detectives prior to you going to the grand jury?
No, sir.
In your mind, was there any significance whatsoever to 5 shots or 6 shots before testifying in the grand jury? In your mind?
Well,
Objection.
Well, I mean, let me rephrase the question.
Rephrase.
I think it was a little confusing when I answered it. Did you think that it was more important for the case to say 5 shots rather than 6 shots when you testified in the grand jury?
I'll see you would say.
So we just heard the redirect examination by the prosecution, basically saying, what's the big deal here? 5 or 6 shots. I mean, according to the prosecution, it is, the 5 shots is relevant to a tattoo that Mr. Hernandez got subsequently. However, for Bradley's purposes, and I want to ask you about this, Geoffrey, Nathan, does it really matter if a witness hears 5 or 6? I mean, I have covered cases, tried cases, where witnesses are all over the map in the number of shots that they think they hear, because sometimes there are echoes or whatever, and they're hearing these things in a very close succession. Do you think this is a point that is a big deal, 5 or 6 shots?
It's all he has to go on, the point of credibility. And here what he has to say is, look, if you are inches away from a firearm being shot across your body and you can't remember how many shots it was, then you can't trust anything that this witness is saying. And that's why he's going there, and it's all he has. And frankly, it's the strategy that may work, because if a jury believes that the witness can't even remember how many shots were fired, I mean, how often do you have a pistol shot, inches away from you? Not too often, right? So it's something you really should be able to remember when you're on the witness stand and sworn to tell the truth, and you've been briefed and debriefed by law enforcement and then district attorneys. And this isn't the first time the question has been asked. And so I think it's a strategy that's a good strategy, and it may well work for him, because in closing arguments, he's really going to hammer in on it.
Well, now, it is relevant to some testimony the jury heard last week on, I think it was on the 17th. We're not going to play the sound right now, but I just want to tell you about it. The judge allowed a tattoo artist to testify. I really didn't know when there was a hearing with this tattoo artist and the judge took the proffer of what he would say, whether he'd allow any of it. But Hernandez got a tattoo with the word God, 2 words, God forgiven, backwards, so he could see it in the mirror, right? And it had like the muzzle of the chamber of a revolver that shows 6 shots, and 5 were empty. 1 was still had a bullet in it. Really interesting, because that's this scenario, the state would argue, that he's basically leaving a little journal, a little diary on his body of what happened. But what made it most relevant, I think, correct me if I'm wrong, is that in the photo that Hernandez took himself, that was found on his phone, early April 2013, shows that there's like redness around the D of God, which means it was a recent tattoo. So he got it shortly after shooting Bradley in the head, if you believe that Hernandez was the shooter. Should this have come in?
Well, I mean, it's circumstantial evidence of tantamount to a confession. And as a consequence, it should come in. It's part of the defendant's body. And it is further noteworthy that tattoos are part of federal criminal databases. So when you run somebody and you run their federal criminal records, local state records, law enforcement has a specific tattoo section. So it's part of criminal defense work. I mean, tattoos, unless you go through the removal process, are otherwise permanent, and they are identifying marks, and as a consequence, they're admissible. Yep.
Because this case comes down to, is Bradley the shooter? Is Hernandez the shooter? I would love for Aaron Hernandez to get on the stand. Any chance of that?
I don't think so, Beth. First and foremost, he's probably smart enough to testify in his own behalf, frankly. If he were that smart, he wouldn't be up on double murder here and then a murder back a couple years ago. He's just a kook. I mean, that's all you can classify this defendant as, and he's not qualified to testify on his own behalf. So now, and rarely do defendants testify in a first-degree murder anyway on their own behalf. So particularly in this instance, that would be something that would have all of us pundits really scratching their heads wondering, wow, how did this happen?
I think part of Jose Baez's strategy with Bradley in cross-examining him, and he did a very lengthy, thorough cross-examination, was to try to get under his skin, try to rattle him. And he made some snarky comments to him. Good strategy?
Generally speaking, I think it's a good idea to leave that for another day and another forum, but if that's what Baez feels is the only way to undermine the testimony here, because it's damning testimony, then so be it. Far be it from me to say that it's a bad strategy. The only worry that I would have is that it just backfires. The jury doesn't like it. If they don't like what you're doing, Mr. Defense Lawyer, guess what? Your client's likely to be found guilty, so you really got to be careful when you do stuff like that, Beth.
There's been a lot of evidence about, the details of the night of the shooting, when the two men, Hernandez and Bradley, went to the Cure Lounge and another bar, and then the details of the shooting, and then the aftermath, where they went and what they did. And yesterday, there was testimony from the former girlfriend of Alexander Bradley, who is the mother of his child. And they went to her place. Now, her name is Brooke Wilcox, and I just want to play a little bit of what Brooke Wilcox had to say about that night. So let's go to yesterday's testimony, and it would be number 2. Anthony.
Yes.
In addition to recognizing the voice, did you have this person's phone number saved in your phone?
Yes.
And who was it who called you in the afternoon of February 13, 2013?
Aaron.
The defendant, Aaron Hernandez?
Yes.
And what did Aaron Hernandez say to you when he contacted you?
He asked me if I had heard from Alex. He told me he was supposed to meet him at the airport. Kind of like all over the place. He said he had to leave. He said he knows Alex doesn't have money. He has a ticket for him. And he kept asking me if I knew where he was or if I heard from him. And I said, no, I thought he was with you. Maybe, I don't know. I was asking, where did you guys go last night? And he said they went out to a club. He was supposed to meet him after that. And I said, no, that was it. And I told him, I would tell him that you're looking for him.
Did you say what state or city he was in?
At that point, I knew that, yeah, Miami.
Objection.
Overruled.
No, may we approach?
No.
Miami.
Now,
Objection, move to strike. That's the reason that you went to the internet and began searching for Aaron Hernandez, correct?
No,
You went to Spokio.com as one of the sites, right?
I believe so.
You looked up Aaron Hernandez's address, right?
Right.
You wanted information so that you and Sherrod could pin this on Aaron Hernandez.
Wrong.
You attempted to get in Spokio.com private personal information about Aaron Hernandez, correct?
Wrong.
You made these queries into Aaron Hernandez's personal information, right?
I don't understand what you're asking me.
You got on the computer and did searches.
I did
Aaron,
I did some of the search.
And some of the searches were
Aaron.
Hernandez address.
Some.
Right?
I did some. Aaron did some. I didn't do them all.
Well, let's talk about that. I'm talking about the ones that you did, right?
Okay.
And now, you got on the computer and you typed Aaron Hernandez address, correct?
I must have. I don't have a specific recollection of typing that out, but I must have.
You didn't ask Sherrod, hey, where does Aaron live?
No, I didn't ask him.
You typed in Aaron Hernandez girlfriend
Yes.
on the 16th of July, 2012.
Yes.
Because you wanted to get more information about Aaron Hernandez.
No.
You don't have any training in ballistics, do you?
No.
You don't know much about guns at all.
No.
You don't know what gun powder residue is, or gunshot residue is, do you?
No.
You're not familiar with the term GSR, are you?
No.
You've never seen Sherrod reading forensic science books, have you?
No.
I want to draw your attention to a point in time before Sherrod got his deal with the government. So I'm asking you to think about a point in time after July 16, 2012, and before Sherrod got his deal with the government. Do you understand that time frame?
No, I don't know the exact day that he got his deal to understand the time.
Well, you know it was in October or so of 2013,
I
right?
don't know that, no.
Well, then I'll draw your attention to a time period between July 2012 and October of 2013.
Okay.
All right? Now, in those periods, in that period, you testified about this on direct. Sherrod told you that the police and the Commonwealth, that they had the wrong gun, right?
Yes.
He told you he knew where the gun was, right?
No, he didn't tell me he knew where the gun was.
Well, he told you he knew that the gun they're talking about was not the gun, right?
He didn't, he said that that gun couldn't have been found in a car.
He said that
It
the
was in
gun
reference to them finding it in a car.
He
Can you
said
elaborate?
he said that that gun was long gone,
Right.
right? And I want to just highlight another thing that Sherrod told you before he got his deal. You are clear, right, that Sherrod made statements to you about how he says Mr. Hernandez's body was with respect to the car, correct? This Toyota 4Runner, right?
Can you repeat that, like, all together?
Sure. Let me ask this way. At that time, before Sherrod got his deal, and even up to today, right, you have no earthly clue whether a Toyota 4Runner or the front seat in a Toyota 4Runner is large enough to fit a 240-pound professional football player and a 260-pound drug dealer, do you? Objection.
Well, I don't know.
Based off of my personal knowledge of cars or sizes of cars? Is that what you want me to base it off of?
Anything. You have no idea whether.
I mean, I've driven, my friend had one a while ago. I've driven them. They're big cars.
And have you ever measured the dimensions of the window?
No, I've never measured.
Have you ever measured the dimension of the front seat of a Toyota 4Runner?
No, I've never done that.
And in this period of time, before Sherrod got his deal, he told you, now these were his words, that Aaron's, quote, whole body, end quote, was out of the car, right?
He said he stuck his whole body out of the car.
He didn't say, oh, and by whole body, I really mean a little bit of his arm, right?
He didn't elaborate.
He never said, oh, when I say whole body, I don't mean body, I mean wrist area, right?
Said it in elaborate. That's sustained.
He never said any of that, did he?
Objection. You may answer.
He didn't elaborate.
Now, Mr. Hagan asked you about some telephone calls, and he put up some calls on the screen. What was Aaron's telephone number back then?
It was a 203 number.
What was the entire number?
203-606. I don't know the whole number by heart.
Okay, so when he asked you this Aaron's number, he was just pointing that out to you, right?
Right.
Now, he asked you a lot about some calls that were either no pickup or very brief, right?
Mm-hmm. Yes.
You were aware of conversations with Aaron that he was on his way to Arizona, right?
I was aware of what?
That Aaron was on his way to Arizona. And drawing your attention to the time when Sherrod was shot.
Okay.
You said you had some telephone calls with Aaron. And Aaron called you because he said he could not find Sherrod, correct?
Yes.
Mr. Hagan showed you a number of calls and text messages, right?
Yes.
Some of them indicated that there was no pickup, correct?
Yes.
Some of them were early morning calls, right?
Yeah.
You do realize that if it's 7 o'clock here, it's 4 in the morning in Arizona, right?
He wasn't in Arizona the first time he called me, but I mean, I do agree with you that the time frames will be different.
Right. And were you aware that he had layover in Dallas before going to
I wasn't aware of his
Arizona?
schedule. No.
But you do realize that that he was traveling that day, yes?
He told me that, yeah.
And that there is a time frame
Right, yeah.
or a time difference. He never told you that he in any way harmed Sherrod, correct?
That he didn't what?
He never told you that he in any way harmed Sherrod, correct?
No.
Brief indulgence.
Counsel Ronald Sullivan, not Jose Baez, cross-examining Brooke Wilcox, who still has a good relationship with her ex-boyfriend, the father of her child, Alexander Bradley. And, you know, the point of Sullivan's cross-examination, and he was getting a little bit testy with her, but she held her own, was to suggest that she created this story to blame Aaron Hernandez for the shootings because she's protecting her former boyfriend with whom she still has this nice relationship. He was a good father to their child and would take care of her, had custody on weekends, and, you know, they had a good relationship. Well, she held her own. We'll see what the jury does with that. If one or more jurors believes the defense, there could be a deadlock jury. And Geoffrey Nathan, defense attorney out of Boston, how, you know, when there's a deadlock and prosecutors choose to retry a case over again, I've seen different jurisdictions make different decisions. They can try and retry. I mean, what is the norm? Like 3 times and then you call it quits? I mean, if it's a hung jury, they would retry him, I assume, right?
There's no norm. It's abnormal. That means the prosecution really struggled in its first trial, then has to put the evidence on their own table and evaluate it again and make a determination. Can we get a jury to reach a verdict? Obviously, they're trying to have a verdict of guilty, but the equation that they're using is, do we have enough evidence that the jury can make a reasonable verdict, whether it's guilty or not? In the instance, normally what you'll see is after 3, forget about it. They're going to drop the case. Twice isn't too terribly unusual, as we've seen in some of the biggest criminal cases in the country. But after 3 times, you're all done. You're not going to see a guy going up on a 4th trial, Beth.
Now, I want to remind our viewers that we are going to be going live into a Wisconsin courtroom when closing arguments begin, which should be sometime in the very, very near future. They were scheduled to begin 7 minutes ago. In Wisconsin. People are probably assembling in the courtroom. We don't see the feed out of the courtroom yet, but this is the trial of Christopher Torgensen. Now, LawNewz.com has been streaming this trial. The trial started last week. Torgensen is now 37. He's been locked up, though, at least since he was 34. That's when he was charged with murder. He's charged with first-degree intentional murder as well as attempted robbery as a repeat offender, which means the sentence can be higher. We call them predicate felons in New York, but the reference was repeat offender, and he's charged with hiding a corpse. Here's what is alleged to have happened. On October 10th, 2010, he told some people later he went to the home of Stephanie Lowe, who was 22 years old. Stephanie and her boyfriend, according to police, were known sort of cocaine dealers. And on the day of Stephanie's murder, October 10, 2010, Torgensen had purchased some crack cocaine because a witness who sold it to him testified at the trial. But he went to Lowe's home to rob her. He says that was his intention, but she fought back. Now, there's no evidence that there was anyone else there. It was Lo, and she fought back, and he strangled and stabbed her and then hid her body. Her mother reported her missing that day. Well, she was reported missing on the 10th. Her mother last had seen her 2 days before, and her mother did testify that her daughter was trying to turn her life around, that she was changing and she was cleaning up her act. Well, the police always suspected, or had for some time suspected Torgerson because he had talked to up to 6 different people. He had made incriminating statements about what he did to her, to Lo. They were getting ready to charge him without a body. There are problems, but it's not impossible to charge someone with murder. Casey Anthony was charged with murder before her daughter's body, little Kaylee's remains, were found, and then the remains were found, and then they sought death against her. And I have seen successful prosecutions of no body cases. So they were getting ready to charge him with that, and then he ended up cutting a deal where he led them to the body. He's facing life in prison if he's convicted. They found the body and there was a knife in it. And by the way, when the police went to her apartment, when they were let into her apartment after she was reported missing, they smelled like bleach or cleaning, cleaning substances. So it is believed that Torgerson had, after killing her and creating a bloody mess, that he had cleaned it up. Do we have a feed out of the courtroom? Are they live? I'm just getting word that that we can go into the Wisconsin courtroom. We can see the back of Torgerson right now. At least that's what I'm looking at. So, Geoffrey, Nathan, we're going to go into Wisconsin. We'll listen to these closing arguments. I've given you a little recap of what the facts are. I suspect that it'll be a quick verdict, but that could be the prosecutor in me saying that.
May not be able to hear it unless I go to my computer.
It's going to keep talking. Are we going into the courtroom? Okay, I don't see it.
While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instance before the act. It must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond reasonable doubt that the defendant caused the death of Stephanie Lowe with intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The defendant is charged with armed robbery, attempted armed robbery. The crime of attempted armed robbery, as defined in the criminal code, is committed by one who, with intent to commit armed robbery, does an act for the commission of that crime which demonstrates unequivocally, under all of the circumstances, that he or she had formed that intent and would commit the crime except for the intervention of another person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The first element of attempted armed robbery requires that the defendant intended to commit the crime of armed robbery. The crime of armed robbery is committed by one who, first, takes and carries away property from the person or from the presence of the owner of the property, and second, takes the property with the intent to steal, and third, acts forcibly, and fourth, uses or threatens to use a dangerous weapon. Intent to steal requires the mental purpose to take and carry away movable property of another without consent, and the intent to deprive the owner permanently of possession of the property. The crime charged against the defendant in this case, however, is not armed robbery as defined, but an attempt to commit the crime of armed robbery. The second element of attempted armed robbery requires that the defendant did an act toward the commission of the crime of armed robbery, which demonstrates unequivocally, under all the circumstances, that the defendant intended to and would have committed the crime of armed robbery except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone but the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all of the elements of attempted armed robbery have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime, avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, the defendant hid a corpse, and two, The defendant hit a corpse with intent to conceal a crime, avoid apprehension, prosecution, or conviction for a crime. This requires the defendant acted with the purpose to conceal a crime, avoid apprehension, prosecution, or conviction for a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case, bearing upon intent. If you are satisfied beyond reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Consider carefully the closing arguments of the attorney, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by this court. And we'll begin with the state's closing arguments. I just want to tell the jury that a copy of these instructions will be sent to the jury. Go ahead.
Please, court, counsel. Switch to. Ladies and gentlemen of the jury,